welcome to Saturday morning and the wind-up of our special lectures for March 1983 on torts in the 80s. And this morning it is with the greatest of privilege that I have the opportunity of introducing to you Madam Justice Wilson. And those of you who are here probably know that Mrs. Wilson was born in Scotland, educated at Central Secondary School in Aberdeen, also attended the University of Aberdeen, where she obtained her Master of Arts in 1944, going from there to Training College for Teachers in Aberdeen and Dalhousie Law School in Nova Scotia, where she obtained her Bachelor of Laws in 1958 and her Doctor of Laws in 1980. She's a married lady, called to the bar of Nova Scotia in 1958, practiced law in Toronto in the firm of Osler, Hoskin, and Harcourt of Toronto, admitted to partnership in 1968. She's a Queen's Counsel and member of many associations and councils, but a few are a member of the Ontario and National Councils of the Canadian Bar Association, a member of the Board of Trustees of the Clark Institute of Psychiatry, member of the Board of Trustees of the Toronto School of Theology, and member of the Executive Committee of that school, a member of the Board of Trustees of the Canadian Centre for Philanthropy, and she had, unfortunately, to give all of those up when she was appointed to the Ontario Court of Appeal in December 18th, 1975, and as you all know, she now graces the bench of the Supreme Court of Canada. And it's with the greatest pleasure that I introduce Madam Justice Wilson to you.
Thank you very much, Mr. Chairman. Since the theme of this special lecture series is torts in the 80s, and we still have 2/3 of the decade ahead of us, I thought it would be appropriate for me to take a forward-looking approach to my topic, which is the professional liability of architects and engineers. I must begin, however, by admitting that I feel somewhat constrained in taking this approach by my judicial office and the sobering thought that some of you may be presenting these issues for resolution before the Supreme Court before the decade is out. Lest my words come back to haunt me, therefore, I intend to take out my own brand of errors and omissions insurance and focus on the questions which are surfacing in this area rather than on the answers. The liability of architects and engineers is, of course, just one facet of the general topic of professional liability. And developments in one part of the field necessarily have implications for the others. Mr. Wortzman has as his topic the liability of healthcare professionals, and Mr. Justice Krever the liability of lawyers and accountants. Now, I'm naturally loath to expand too far into their territory. However, because I have the advantage of speaking first, I would like to be somewhat expansive and draw on the law governing the liability of architects and engineers to highlight what I see as some of the key issues in the development of the law in the area of professional liability generally. 50 years have passed since Lord Macmillan made his classic statement in Donoghue and Stevenson that the categories of negligence are never closed. And I think it's fair to say that over that period of time, the courts have endeavored to meet his challenge that, quote, the criterion of judgment must adjust and adapt itself to the changing circumstances of life. And the result has been a progressive, if somewhat intermittent, expansion of the law of negligence so as to provide new or more adequate remedies to injured plaintiffs. One thinks particularly of the developments in the area of negligent misstatement, the Headley-Byrne principle, and the development in relation to the recovery of pure economic loss in Rivto Marine. The dissenting comments of Lord Buckmaster and Lord Tomlin on, quote, the alarming consequences, unquote, of the decision in Donoghue and Stevenson have a hollow ring today. And yet, as you're all aware, the judiciary are notoriously conservative and hesitate to stray down untrodden paths unless they can see very clearly where they're going to lead. Indeed, they remind me at times of the old elder in our first parish in Scotland who laid low with a severe bout of the flu on the night of the Kirk session meeting and advised by his doctor to stay home in bed, said, "But I've got to gang. There might be something I want to vote against." But seriously, creative lawmaking by judges is, I think, more difficult in a commercial context. Certainty in the law seems to be a prerequisite in the business world, and people must be able to conduct their affairs with a reasonable degree of confidence as to the result. I think this is why architects and engineers may be more active than some other professionals in voicing their concern over the present unsatisfactory state of the law on professional liability. How do you protect yourself if you don't know the scope of your exposure? They perhaps, more than doctors or lawyers, feel entitled to know the cost of doing business. What then are the problems that anxiously await solution in this area? And are there any answers on the horizon? Well, possibly the most live and most fundamental issue at the present time is the question whether the same piece of professional misconduct can give a client a cause of action in both contract and tort. There are those who are firmly of the view that it can, and others equally persuaded that the existence of a contract automatically restricts the plaintiff to his contractual remedies. If, of course, concurrent liability does exist, then it is open to the injured plaintiff to choose the most favorable route for him, and the defendant must guide his affairs on the assumption that he will do so. The most obvious step for the defendant to take, and the one which has found favor in the United States where concurrent liability is accepted, is the use of ever-widening exculpatory clauses to protect against both types of liability. As Mr. Ian Outerbridge stated in his 1977 lecture in this same series, standard architectural and engineering contracts in the United States now, quote, appear to be more a statement of what they don't do, rather than what they do. And a similar development may be foreseeable in this country. Yet, until relatively recently, this was a non-issue. Cases decided in the 60s, not only in Canada, but in England and other parts of the Commonwealth, were quite clear in holding that the action lay in contract only. For example, Schwebel and Telekes and Baggett versus Stevens, Scanlon and Co. In the wake of Headley-Burton, there was some thought that concurrent liability might lie for negligent misstatement. I'm sure the Supreme Court of Canada believed it had nipped that view in the bud in the Nunes Diamonds case, but they couldn't have been more wrong. In Nunes Diamonds, the alarm system supplied by the defendant to the plaintiff failed to go off during a theft. The plaintiff argued that one of the defendant's employees had negligently misrepresented that the system would provide adequate protection and was in good working order. Writing for the majority, Mr. Justice Pigeon explained, and I quote, "The basis of tort liability considered in Headley-Burton is inapplicable to any case where the relationship between the parties is governed by a contract, unless the negligence relied on can properly be considered as an independent tort unconnected with the performance of that contract. This is especially important in the present case on account of the provisions of the contract with respect to the nature of the obligations assumed and the practical exclusion of responsibility for failure to perform them." He continued, "It is an essential basis of the contract between the parties that the defendant is not to be in the situation of an insurer. It is in consideration of this stipulation that the charges are established solely on the probable value of the service and not on the value of the goods intended to be protected. To make the protection company liable in the case of a failure of its protection system, not for the stipulated nominal damages, but for the full value of the goods to be protected, is a fundamental alteration of the contract." Mr. Justice Pigeon applied the same approach to an engineer's liability less than a year later in the Halvorson versus McLennan case. He discussed the nature of the contract between the plaintiffs and the defendant engineering company and then said, "This means also that Halvorson's only possible claim against McLennan is for negligent performance of its contract for erection services and not in tort as was contended." Now, given the weight of authority for the contract-only position, what has prompted the recent and seemingly persistent trend towards concurrent liability? I think one can count for it on two bases. The first is a perception on the part of litigants that contract remedies are inadequate, or at least less adequate than tort remedies in certain areas. Another way of putting it is to say that contract remedies have not kept pace with the expansion of tort remedies, whether the latter arose from judicial interpretation or from statute, and that litigants with contractual claims want to be able to take advantage of the greater opportunities available in tort. The second basis for the trend towards concurrent liability, I think, is the desire of the courts to rationalize the development of the law. It is, of course, the genius of the common law that it's able to grow and adapt to changing societal standards and values. And the common law contains a fascinating balance between concepts which facilitate change, such as the standard of the reasonable man, and concepts such as precedent, which tend to restrict change. The balance between these elements may differ in the various areas of the law, and consequently, growth may be uneven. Sometimes anomalies arise, which not only call into question the result of a specific case or line of authority, but challenge the entire conceptual framework within which that area of the law is approached. Thus, it may be that the concurrent liability debate persists not merely out of dissatisfaction with the contractual remedies available to the clients of professional people, but out of a more general dissatisfaction with traditional notions of the ambit and function of the respective spheres of contract and tort law. Now, I think it's more satisfactory, especially on this early hour on a Saturday morning, to look at the specifics before we tackle the broader philosophical issue. And there are two particular areas in which dissatisfaction with the available contractual remedies has given rise to a significant pressure for concurrent liability. And they are, firstly, limitation of actions, and secondly, contribution among wrongdoers. A third area of difference between contract and tort, although one less productive of litigation involving architects and engineers, is damages. And I want to say a word or two about each. Limitation of actions. In Ontario, professional liability actions against architects must be brought within 6 years after the cause of action arose pursuant to Section 45 of the Limitations Act. And this section applies to actions in contract as well as in tort. Engineers are in a rather unusual position in that Section 28 of the Professional Engineers Act provides for a 1-year limitation period for actions for professional negligence or malpractice, subject to the discretion of the court to extend that period. But in either instance, the important distinction between tort and contract actions lies in when the cause of action arises for purposes of the running of the statute. In contract, a cause of action arises and the statute of limitations begins to run at the time of the breach, regardless of whether the plaintiff could have discovered the existence of damage at that time or not. It's interesting to note that in the 60s, when the leading cases on concurrent liability in a statute of limitations context were decided, the courts were of the view that regardless of whether the action was framed in contract or tort, the cause of action arose at the same time. In substantive terms, therefore, it really made no difference. In Bagot and Stephen Scanlon, Lord Justice Diplock considered the question of whether an action by a client against an architect for negligent supervision of the laying of a drainage system could be founded in tort as well as in contract. It was conceded by counsel, and his lordship agreed, that the statute of limitations began to run in contract at the time of the breach, that is, when the drains were laid. The drains were laid more than 6 years before the action commenced. It was also conceded by counsel that damage did not arise for purposes of a negligence action until sometime within the 6-year limitation period. Lord Justice Diplock expressed some difficulty with this admission, since he believed that for tort as well as for contract purposes, damages arose at the time the drains were laid. Notwithstanding this observation, his lordship concluded that the action lay only in contract. He said that, quote, "The relationship which created the duty of exercising reasonable skill and care by the architects to their clients arose out of the contract and not otherwise. The complaint that is made against them is of a failure to do the very thing which they contracted to do. That was the relationship which gave rise to the duty which was broken. It was a contractual relationship, a contractual duty, and any action brought for failure to comply with that duty is, in my view, an action founded in contract. It is also, in my view, an action founded in contract alone." Now, a similar approach to Lord Justice Diplock's was taken not long afterwards by Laskin, J.A., then on the Ontario Court of Appeal, to a case involving the liability of a notary with respect to a deed to the plaintiff's matrimonial home, the famous case of Schwebel versus Telekes. Strictly speaking, Laskin, J.A. did not find it necessary to decide whether a concurrent action existed in tort, since he based his opinion on the ground that any cause of action which existed arose at the same time, the time when the defendant rendered his services under either theory. This rule may seem harsh in cases where the plaintiff had no way of knowing that a breach of contract had occurred, a fact which Laskin, J.A. acknowledged. But he thought it was important that it served the purpose of putting a finite time limit on the professional's liability. At a certain point, he could put away his files and cease to worry about the work he had done in the past. More recently, however, there's been a general expansion of the time frame in which tort actions can be brought against architects and engineers, and this was the result of a development through the House of Lords judgment in Anne versus Merton London Borough Council following the English Court of Appeals decision in Sparham Souter versus Town and Country Developments Limited. These cases stand for the proposition that liability in tort for damage arising from a structural defect to a building accrues only when the plaintiff actually discovers the damage or ought to have discovered it by exercising reasonable diligence. And these English cases have, of course, been followed in the Canadian courts. For example, Mr. Justice Corey's recent judgment in Robert Simpson Company versus Foundation Company of Canada Limited. And this approach will undoubtedly continue to be persuasive. Indeed, the tort rule on limitations must surely have reached its high water mark in Brook Enterprises Limited versus Wilding, a decision of my colleague, Mr. Justice McIntyre, then sitting on the British Columbia Supreme Court. In that case, he ruled that the statute of limitations in an action against an architect for the negligent design of a building did not begin to run against a third-party purchaser of the building until he purchased it. He reasoned that the plaintiff had no cause of action in negligence and no damage to him existed until he acquired the defective building. In effect, the architect's liability for negligent design is revived with each successive purchase and can therefore go on indefinitely. Now, the present tort rule and limitations obviously gives a far superior remedy than does contract in situations where negligent design or construction work is not apparent until some years after a building has been completed. And in the Robert Simpson case, the action arose in tort, and it was not necessary to his decision for Mr. Justice Corey to consider whether in a case of concurrent liability the situation would be different. Nevertheless, he took the opportunity to review the state of the law with respect to limitation of actions, and his comments are instructive. The defendants in the Simpson case had built the ceiling of one of the plaintiff's department stores, and the store was located in a shopping mall. Although the store was built specifically for occupancy by Simpsons, the construction contract was with a third party, presumably the developer of the complex. And some years after the construction was completed, it became apparent that the ceiling was unsafe, and the plaintiff alleged that the cause was the defendant's negligence. The defendants argued that the claim was statute barred. The construction had taken place more than 6 years before the lawsuit was commenced. The discovery of the defect, however, took place within the limitation period. Mr. Justice Corey applied the English cases Annes and Sparham Souter and held that, quote, where there is no contractual relationship between the parties and the plaintiff's claim is based upon work negligently performed and covered up, the cause of action does not accrue and time does not begin to run until such time as the plaintiff discovers the damage or reasonably ought to have discovered it. He also expressed the view that Schwebel and Telekes should be, quote, restricted to those cases where a contract has been entered into whereby the defendant is to provide personal services which require him to exercise the particular skill and training of his calling. So on this approach taken by Mr. Justice Corey, architects, engineers, and other professionals would continue to be protected by Schwebel versus Telekes vis-a-vis their clients with whom they are in a contractual relationship. It's interesting in that case, Mr. Justice Corey expressly left open a much bigger question of what should happen in situations outside of the professional context in which there is a contractual relationship between the parties and the defendant's negligence constitutes a breach of contract. He did, however, express concern with the idea that the result should turn on the seemingly anachronistic distinction as to whether the action was framed in tort or in contract, and I'm sure that the concern he expressed is shared by many others. Now, I want to say a word about contribution, because this is another area where the distinction between tort and contract surfaces. And the courts have felt rather ill at ease, I think, with the distinction between contract and tort in contribution and apportionment of damages when more than one defendant is liable. And this is really a dilemma that stems from the scope of a statutory provision, in this case, the Negligence Act. And notwithstanding some hints from Chief Justice Laskin that there may be an equitable right of contribution in cases of concurrent breach of contract, namely two people, each with their own contract, and both in breach. He suggests in the Giffels Associates and Eastern Construction case that there may be a right of contribution in contract. But despite his comments, it's generally assumed that contribution is available in Ontario only to concurrent tortfeasors under the provisions of the Negligence Act. The interest in framing an action in tort in this kind of situation is not so much to protect the plaintiff, who of course will be entitled to full compensation from either wrongdoer, but to enforce a sharing of the burden among the defendants in proportion to their respective culpability. And I had the chance to consider whether concurrent liability in contract or tort ought to exist in this context in the very first two cases I sat on when I joined the Ontario Court of Appeal, Dominion Chain versus Eastern Construction and Dabus versus Zuliani. And Dominion Chain raised the issue of concurrent liability on the part of an engineer and a building contractor. The plaintiff, Dominion, had contracted with Eastern, the contractor, to construct a building. He had also contracted with Giffels Associates, a firm of engineers, to provide advice and supervise the construction. The roof of the building was defective, and Dominion sued both the contractor and the engineers. The contractor had protected itself with an exculpatory clause, which effectively excluded its liability to Dominion. Dominion's suit against the engineers, however, was successful. The engineers claimed contribution from the contractor, on the theory that the provisions of the Negligence Act applied to this situation. And at trial, Mr. Justice Lerner held that the contractor must bear 75% of the damages awarded against the engineers. And the main question on appeal, of course, was whether this contribution award could stand. We all agreed that it could not, but I disagreed with the reasoning of my brothers Jessup and Zuba. Writing for the majority, Mr. Justice Jessup found that the negligence of both the engineers and the contractor gave rise to liability in tort as well as in contract. This meant effectively that they were concurrent tortfeasors for purposes of claiming contribution under the Negligence Act. Nevertheless, because the contractor had a special defense to a negligence action, namely the exculpatory clause, he was not liable for purposes of the statute, and accordingly, no claim for contribution could be made against him. It's quite clear from the majority opinion, however, that in the absence of the exculpatory clause, the majority would have found that contribution was available. And indeed, this is just what happened in the companion case of Debus and Giuliani. I agreed that contribution was not available under the Negligence Act, but on the basis that the defendant's liability was in contract only, and the Act, the Negligence Act, therefore had no application. I believed at the time that the weight of both principle and authority inclined in this direction. I said, quote, "If the acts or omissions complained of by the plaintiffs are in relation to the very matters covered by the contract, the essence of the plaintiff's action is breach of the contractual duty of care rather than breach of the general duty of care owed to one's neighbor in tort. The scope of the contractual duty may be wider than the scope of the tortious duty, and the standard of care may be higher or lower than the standard in tort. In my view, the provisions of the contract must govern in such circumstances." Now, the Dominion chain case was appealed to the Supreme Court of Canada under the name of Giffords Associates versus Eastern Construction. And Chief Justice Laskin, in delivering the opinion of the court, did not find it necessary to decide the question whether concurrent liability lay in contract or tort, since he was able to affirm the majority judgment below on the ground that the contractor had in any event excluded its liability through the exculpatory clause. In retrospect, it's very unfortunate that it was the Dominion chain case and not Debus and Giuliani, where there was no such exculpatory clause, which came before the Supreme Court, because I think that some authoritative guidance on the point might have resolved the issue we're all struggling with. The British Columbia Court of Appeals decision in Surrey versus Carroll Hatch and Associates shows how the courts have got around the contract in order to come to grips with the question of contribution and apportionment. In Surrey, the plaintiff municipality hired an architect to design a new police station. The architect retained an engineering firm to advise on structural matters. And one of these matters was the suitability of the site. And upon a preliminary inspection, the engineer concluded that extensive soil tests would be necessary. The architect didn't want to do the tests. Later, the municipality asked for a statement of what soil structure analysis had been done, and the architect persuaded the engineers to give an account of the preliminary soil testing which the municipality took to be an adequate soils report. And of course, shortly after completion, the building was damaged as a result of settling, which occurred because the soil was unable to bear the weight of the structure. The trial judge found that the architect was liable in contract and the engineers were liable in tort. Upon application by the engineers, the judge applied the provision of the BC Contributory Negligence Act and apportioned the fault 60% upon the architect and 40% upon the engineers, and established a right of contribution between them. On appeal, Hinkson J.A. had no difficulty in finding both defendants liable. He was not, however, content to rest the contribution award on a finding that one defendant was liable in contract and the other in tort. Although counsel cited lower court authority to the effect that the British Columbia Contributory Negligence Act was sufficiently broad to encompass breaches of contract, Mr. Justice Hinkson expressly refrained from ruling on this point. Instead, he based his contribution award on a finding that both defendants were liable in tort. Hinkson J.A. held that the architect was liable for negligent misstatement and breach of a duty to warn his client of the inadequate soils test, in addition to his contractual liability. One might have thought that such a finding would have been precluded by the Supreme Court of Canada's decision in the Nunes Diamonds case. Mr. Justice Hinkson adopted the somewhat doubtful distinction that Nunes Diamonds does not apply to situations in which a party to the contract, quote, because of the relationship established thereby between the parties, assumes common law duties in addition to the obligations imposed by the contract. When such a duty is not performed, it is not then open to the negligent party to attempt to avoid the consequences of his negligence by invoking the contract if its terms do not limit the liability. Now, while the British Columbia Court of Appeal exercised a considerable degree of ingenuity in reaching the desired result in Surrey, I'm not sure that its analysis is totally satisfactory. The court does not give much guidance as to when this concurrent common law duty will be superimposed on a contract. One is left with the impression that it might be permissible to superimpose tort liability on contractual liability, provided that the object is not to alter substantively the relationship between the parties, but only to alter the relationship between one of the parties and a third party. I think that the better approach is to face the question squarely, whether in terms of concurrent liability in contract and tort, or in terms of contribution among those concurrently in breach of a duty to someone else, regardless of whether the duty lies in contract or tort. I want to say a brief word in damages because I think it's the third area in which suing in tort as opposed to contract could lead to different results. Questions of remoteness and measure of damages haven't been canvassed extensively in the context of architects and engineers' liability. And I don't propose to go into great depth on the nature of the difference between contract and tort damages, as this topic, I think, is probably worthy of a lecture by itself. On the other hand, I think that the apparent lack of pressure for concurrent liability in damages cases deserves some consideration. It might be argued that this arises from the somewhat confused state of the law itself. There's certainly an abundance of dicta to the effect that, at least as far as remoteness is concerned, the damages in contract and tort are already the same. I think a better explanation is that although damages may in a number of situations be different in contract and tort, in neither is there a consistent advantage or disadvantage for plaintiffs or defendants. In some circumstances, contract damages will be higher. In others, tort damages will be higher. And since the advantage or disadvantage arises out of a number of relevant factors, I believe that the courts are more comfortable with the continuation of the distinction between contract and tort in this area than in the situations we discussed earlier, in which an advantage automatically accrues when tort law comes into play. The difference between contract and tort damages begins, of course, with the fundamental basis on which damages are calculated. And I would refer you to Seaton J.A.'s judgment in Sealand of the Pacific versus McHaffey, one of the few engineers' liability cases in which the issue of damages is discussed. And Mr. Justice Seaton said there, the measure of damages in a breach of contractual warranty situation is based upon putting the plaintiff in the position he would have been in, not if the representation had never been made, but if the representation had been true. The plaintiff, in other words, in contract is entitled to the benefit of his bargain. In some instances, this will be more favorable to the plaintiff, and in others, less so. But it seems plausible that the court need not alter the substance of the bargain by giving the plaintiff a concurrent action in tort. Dr. McGregor, in his treatise on damages, demonstrates that while some of the principles which operate to restrict the ambit of this general rule of measure of damages are the same in contract and tort, for example, the principles of mitigation of damage and certainty of proof, others retain subtle differences. And one of these is the principle of remoteness. And as McGregor points out, the rule in Hadley and Baxendale, however it's expressed, retains the concept that damages should be limited by what should have been in the contemplation of the parties themselves. In some cases, this will obviously enhance a plaintiff's contractual damages in cases where he's communicated to the other party a special circumstance which would render the damages within the contemplation of the parties, although not necessarily reasonably foreseeable for tort purposes. McGregor uses the example of a loss of goods, which constitutes both a breach of contract and a conversion. If the plaintiff has sold the goods at an exceptionally high profit to a third party, he will not recover the exceptional profit in a tort action. Under normal circumstances, he wouldn't recover in contract either. But if he had informed the defendant of his intended sale so as to bring the damages within the contemplation of the parties, then he would recover the exceptional profit in contract, although not in tort. On the other hand, the contemplation of the parties rule may work against a plaintiff in a contract action. For example, in a normal commercial contract, it's been held there's no recovery for non-pecuniary loss, such as mental distress, since this will not normally be within the contemplation of the parties. This is true, notwithstanding the fact that damages for non-pecuniary loss may be available in tort. As McGregor puts it, the scope of the protection afforded to the plaintiff is sometimes wider in tort and sometimes wider in contract, depending on the voluntary factor in contract varying from agreement to agreement of the contemplation of the parties. Now, I would refer you to a good example of the contrast between the contract and tort rule of remoteness of damage, which arose on one of the last appeals I sat on in the Ontario Court of Appeal, case called Kinsel and Stringer. This was a very interesting case. It was a case in which a solicitor's negligence resulted in his client's failure to get good and marketable title to the farm he had purchased. The client subsequently purchased a second farm conditional on his ability to give good title to the original one. He therefore was unable to sell it, and the purchase of the second farm accordingly fell through. When the client finally was able to purchase the second farm, its value had increased substantially. And one of the heads of damages for which he claimed was the increase in the cost to him of purchasing this second farm. Mr. Justice Zuber, with whom Mr. Justice Goodman agreed, could find no difference in the tort and contract standard of remoteness. They just applied reasonable foreseeability as the test in both cases. Mr. Justice Zuber refused to award damages for the increased cost of the second farm, saying that, quote, "The damages that flow from the loss of profits from a secondary bargain lie on the far side of a Rubicon that should not be crossed. Reasonable foreseeability takes us only to the shore." I disagreed. I applied the contract test for remoteness as articulated by Lord Reed in Kufus versus Zarnikow, and held that the frustration of a subsequent transaction through the defendant's breach was an event which, quote, "would have appeared to the defendant as not unlikely to occur." Behind the semantic difference between the tests, I believe that the real distinction we can discern is the extent to which the reasonable contemplation of the parties to a commercial agreement is given weight in the application of the strict contract test. Now, we've examined the three areas where, in practical terms, there are different consequences of proceeding in contract and in tort. And I have gone on in my paper to try to analyze why there are these two different approaches for and against concurrent liability. And it's obviously an area that has to be settled in the very near future. I see it in terms of the scope of freedom of contract and the extent to which the law is prepared to allow parties to make their own rules, as opposed to subjecting the parties to the responsibilities and liabilities imposed by law. I'm sure there are many different ways in which this philosophical issue can be analyzed, and various writers who have written learned articles on the subject have taken different approaches. But I do want to end by saying that even if the impetus for the concept of concurrent liability was in the first instance, as mentioned earlier, a dissatisfaction with contractual remedies in the areas we've mentioned, limitations, contribution, and to a lesser extent, damages. It could very well be that the persistence of the idea lies in a changing perception of the role of contract law. And the role of contract law may now be being seen as secondary. Tort law determines liability even in a contractual setting, except to the extent it has been modified by the express provisions of the contract. And if this is indeed the direction in which we are moving, then the next logical step would seem to be to determine to what extent modification by contract should be permitted. And if we go further in that direction, then it seems to me that exculpatory clauses in these contracts will become a prime target. Whatever approach is ultimately found to be best, concurrent liability or no concurrent liability, I think that the commercial context of the problem, particularly for architects and engineers, makes certainty in the law extremely desirable. In practice, I believe that courts, practitioners, and professionals could accommodate to either approach, provided it was clearly settled one way or the other. We badly need authoritative guidance from the Supreme Court of Canada on this issue, and I am hopeful that the opportunity will arise for the court to provide it in the very near future. Thank you very much indeed.